Good day, Crime Talk aficionados. We have a great show for you today. First, the judge calls BS on one of the defense's motions in the Bryan Kohberger matter. Lori Vallow, closing arguments. The jury will probably be deliberating by the time this video gets up. Another teacher in trouble. A trial going on here in Colorado provides an excellent example of what is referred to as extreme indifference. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Before we get to the docket, remind you to go to crimetalksearch.com. Why, you may ask? Because you need to sign up for a background subscription service, one that you can cancel at any time. But while you have that subscription, you can do as many background searches as you desire. So maybe it's you want to do one, maybe you want to know the background of people in a particular case that you're following online. Go to crimetalksearch.com. You'll be able to do that. You can do as many searches as you desire on anyone here in the United States. And that background search is prepared while you wait, and you're going to get information about the individual that you're searching. For example, phone numbers, email addresses, social media presence, whether they have liens against them, judgments. Are they married? Are they divorced? Do they have a criminal history? Are they on one of those registries? Yes, everything you want to know about somebody that you're interested in, whether they're coming into your life, maybe it's a case you're following, or maybe it's the parents of the kids that are coming over hanging out with your kids and you're not getting that warm, fuzzy feeling. Go check out the parents. Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and get to today's show. Now, last week, we went through a lot of the motions that came out and judges' orders that came out in regards to the Bryan Kohberger case. We had the show on Friday about the family members in the courtroom order. We went through that extensively. All the motions in limine that the court granted, as well as the touch DNA contact order, as well as the motion in limine as it relates to the make and model of the suspect vehicle, as well as the order regarding motions in limine that were granted. But there was one motion that I didn't go through as thoroughly as I should have, and that was the order on the state's motion in limine regarding the neuropsychological and psychiatric evidence. Now, as you know, Bryan Kohberger is charged with 4 counts of murder plus 1 count of burglary in relation to the death of 4 college students back in Moscow, Idaho on November 13th of 2022. Well, you can raise what they refer to as a mental health defense. All right. Basically saying I'm not competent, I have some sort of mental disease or defect. Basically, it's not guilty by reason of insanity. And so the prosecution in this case filed several motions saying, hey, we got these reports about the neuropsychological and psychiatric evidence, Bryan Kohberger. Are they trying to raise this as somehow trying to show that Bryan Kohberger could not form the mental element required, the knowing element of the offense to commit these crimes, which is a valid defense. You could raise that. The defense says, no. We want to be able to raise these issues because we believe that Bryan Kohberger is going to have some unconventional courtroom demeanor, and we want to be able to explain it. And yes, they're trying to get in there, hey, he's got these conditions, and so therefore, you'd be a little more lenient on him than he would be with somebody else, right? Tough road to hoe because the guy's in a PhD program. Anyway, so I believe I did not go over this as thoroughly as I did last time because I thought the show was running a little long and I wanted to get to it. But I went back over it again this weekend and I think it's worth going through the entire order. So let's get to it. The order on the state's motion in limine regarding the neuropsychological and psychiatric evidence. Intro. The state seeks to prohibit defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts, Dr. Rachel Orr and Dr. Eileen Ryan. Specifically, the state objects to the testimony proposed in Dr. Orr's and Dr. Ryan's respective expert disclosures, which includes their reports. The state argues the proposed testimony falls outside the mental condition evidence allowed by Idaho Code Section 18-207. Defendant responds that he's not relying on the proposed testimony as a mental element defense under 18-207, noting his relevant diagnosis are physical conditions, not mental conditions. Rather, he intends to present the evidence to aid the jury in understanding both the physical implications of his diagnosis and contextualizing his allegedly unconventional courtroom demeanor. Oral arguments on this matter was held on April 9th, after which the court took the matter under advisement. The court finds that if defendant does not testify, evidence of his diagnosis to explain his courtroom demeanor is not relevant and or inadmissible under Rules of Evidence 403. Ruling is reserved as to certain behaviors that may become relevant in rebuttal, except for expert testimony that he was physically unable to commit the crimes for which there is no disclosed opinion. Standard. The question of whether evidence is relevant is one of law, while the decision to admit relevant evidence is discretionary. On discretionary matters, the trial court must correctly perceive the issue as one of discretion. 2, act within the outer boundaries of its discretion. 3, act consistently with the legal standard applicable to the specific choices available to it. And 4, reach its decision by the exercise of reason. Facts. During the course of this case, the defense team retained Dr. Rachel Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of the defendant and issue a report. She ultimately diagnosed defendant with autism spectrum disorder, level 1, without accompanying intellectual or language impairment, ASD, and obsessive compulsive disorder, among other things, and then lists several exhibit numbers. She also listed various diagnoses for which defendant met the criteria in the past. One of these was developmental coordination disorder. According to Dr. Orr, ASD, the autism spectrum disorder, is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social and behavioral features. It causes deficits in which affected individuals perceive and react to others and their environment, causing problems in social communications and interactions, repetitive behaviors, and narrow range of interests. There's a wide range of autism symptoms and severity. Deficits can include a restricted range of affect, atypical eye contact, displaying facial expressions or movements that do not match what is being said, failure to consider social cues, having trouble with speech reciprocity, and repetitive behaviors. While defendant is diagnosed with the least severe form of ASD and by all accounts is highly functioning, both Dr. Orr and Dr. Ryan noted deficiencies in his behavior to include intense eye contact, restricted range of affect, occasional subtle rocking of upper torso while seated, awkward gestures and interaction, atypical tone, lack of appreciation for personal space, and pedantic speech. However, Dr. Orr also observed that defendant demonstrated typical social behaviors such as fairly consistently, though not intense eye contact, polite demeanor, and social conventions, for example, shaking hands upon greeting. She noted the defendant engaged in conversation and was never overly inappropriate. Dr. Orr noted that the defendant manages sensory processing differences by soothing activities like driving and extensive time in the dark. Defendant's OCD is manifested through compulsive cleaning behaviors and taking precautions to avoid contamination, sickness, or germs. He excessively washes his hands and reportedly uses gloves during basic everyday tasks. Although the defendant does not carry a current diagnosis of DCD, Dr. Orr opines that he met the criteria for the diagnosis in the past, she explains in her report. Defendant's educational history, parents' report, and evaluation results all provide evidence that the defendant experienced significant deficits in motor functions in the course of development, which in turn contributed to problems meeting physical, typical, motor, and coordination milestones of childhood. For example, problems catching balls, handwriting, riding a bicycle. While motor problems have not impacted his functioning significantly in many years, the defendant continues to present with impairment in fine motor dexterity and vulnerabilities in visual motor functions, evidence in his cognitive profile and observations of his behavior. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was the defendant moved his whole arm and repositioned his upper body slightly to manipulate the items effectively. In her cognitive profile, she stated that defendant's visual motor skills were relatively weak in the context of his overall profile, particularly when precision or dexterity were involved. Example, copying, visual motor sequences, consistent with his history of fine motor deficits. When isolated, defendant's fine motor dexterity and speed were impaired bilaterally in the first percentile, likely impacting his visual motor performances as well. According to the declaration of Dr. Jeffrey Lewine, submitted by the defendant as Exhibit D1 to his response to the state's motion, ASD, OCD, and DCD are either neurodevelopmental or neurobiological disorders as opposed to mental conditions caused by extreme physical factors or events. He notes that an MRI of defendant's brain shows objective evidence of disrupted brain structure in several nodes of the social network. Analysis. Idaho Code Section 18207 is not applicable. Section 18207 Idaho Code applies to any issue of mental condition in any legal proceeding at which the defendant's mental health condition may be an issue. It provides in relevant parts, 1. Mental condition shall not be a defense to any charge of criminal conduct. Nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind which is an element of the offense subject to the rules of evidence. Under the statutes, evidence of mental condition is expressly permitted to rebut the state's evidence offered to prove criminal intent or mens rea. Any expert testimony admitted on this issue of mens rea or state of mind under Idaho Code Section 18207 must speak to an element of the crime. Here, however, defendant is not intending to use his diagnosis to challenge the state of the mind element of the crimes which he is charged. In fact, he is not intending to use his diagnosis as a reflection of his mental state at all disputes that they are mental conditions in the first place. Thus, because defendant is seeking to introduce his diagnosis to explain physical deficits rather than mental deficits that qualify him from forming the intent necessary to commit the crime, 18207 does not govern. Having determined that Idaho Code Section 18207 does not apply, the next question is whether evidence of defendant's diagnosis is relevant. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Rules of Evidence 401. Whether a fact is of consequence or material determined by its relationship to the legal theories presented by the parties. Even if relevant, the trial court has discretion to exclude the evidence if the probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considering of undue delay, waste of time, or needless presentation of cumulative evidence. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. With regard to evidence of his ASD, defendant contends it is relevant to explain that his ASD diagnosis is a physical condition and how it presents in his demeanor. Specifically, the defendant asserts testimony about his ASD will help the jury understand that his behavioral characteristics, such as his flat affect, intense eye contact, awkward body posture, and lack of emotive responses are associated with his ASD and should not be interpreted as a sinister light. The defendant argues he should be able to introduce this evidence at the outset of trial. The state responds that the defendant's demeanor is not a fact of consequence in this case and is not even evidence the jury can consider, at least if he does not testify. To this end, the state relies on a body of law regarding prosecutorial misconduct in commenting on the defendant's demeanor as evidence of guilt. In one representative case, United States v. Schuler, the court observed that a defendant's courtroom behavior off the witness stand is not admissible evidence and is legally irrelevant to the question of his guilt of the crime charged. Thus, in the absence of a curative instruction from the court, a prosecutor's comments on the defendant's off-the-stand behavior constitutes a violation of the due process clause of the Fifth Amendment. The clause encompasses the right not to be convicted except on the basis of evidence adduced at trial. While the relevance of defendant's demeanor is raised in a different context here, the principles of his body of law apply equally. The Supreme Court has declared that one accused of a crime is entitled to have his guilt or innocence determined solely on the basis of the evidence introduced at trial and not on grounds not adduced as proof at trial. The jury will be instructed as to what evidence is allowed to consider it in arriving at its determination of guilt or innocence, sworn testimony of witnesses, exhibits which have been admitted into evidence, and facts for which the parties have stipulated. A non-testifying party's demeanor is not included and therefore legally irrelevant to the question of guilt. While defendant cites to case law allowing evidence of ASD in the criminal context, those cases are distinguishable. In State v. Burr, which defendant predominantly relies upon, the New Jersey Supreme Court found evidence of the defendant's ASD was properly admitted in a child molestation case for two independent reasons. One, to explain that the defendant's actions of having his young piano students sit on his lap was not intended as a sexual grooming, but rather a way to relate to his students, and two, to educate the jury about the oddities in behavior the defendant might exhibit in court or that were described in the testimony of witnesses. These oddities and behaviors were not discussed in the opinion. However, in a prior decision by the New Jersey Supreme Court Appellate Division, the court provided more detail, thus placing the ruling in the proper context. There, the court noted that during a pretrial court appearance, the trial judge became alarmed by the defendant's odd appearance and demeanor, and he arrived to court with a bag of large sign draped over his head. When the trial judge inquired about the dress, the defendant began quoting from the book of Deuteronomy. Concerned, the trial judge ordered a competency evaluation, which revealed that the defendant was demonstrating signs of Asperger disorder, with which he was subsequently diagnosed. The state sought to exclude expert medical testimony at trial about the defendant's diagnosis, but the defendant argued it was relevant to show that his ability to make social judgments was impaired, allowing young female students to sit on his lap and to explain his odd or alarming appearances and mannerisms. The trial court excluded the evidence and the defendant was convicted. Not one of defendant's experts has ever imputed behavior to him that remotely approaches the odd behavior in the Burr case. Moreover, the court has had the opportunity to observe defendants through multiple hearings over the past several months, some lasting all day. Not once has the court perceived defendants to be acting in an odd or incongruent manner or otherwise demonstrating signs at counsel table that would warrant an explanation to the jury. His demeanor has been entirely appropriate. In addition, unlike in Burr, the state has indicated it will not present any evidence from witnesses about defendant's alleged odd behavior. Consequently, testimony about defendant's ASD is simply not relevant if he does not testify. And it says defendant also cites to State v. Boyd and another case. None of these cases support the proposition that a defendant's ASD is relevant to explain courtroom demeanor of a non-testifying defendant. Rather, the evidence in each was used to rebut an element of the crime. Moreover, introducing such evidence risks confusing the issue, misleading the jurors, wasting time, and potentially unfair prejudicing both the defendant and the state. The jury will already be instructed about evidence it is allowed to consider in determining guilt because there is no reason for the testimony except to explain something that a jury is not allowed to consider in the first place, i.e., defendant's demeanor. It may very well cause confusion about the role of the expert's testimony plays in the overall determination of guilt. While the court is not blind to the fact that the jury will be scrutinizing defendant's courtroom behavior during trial, allowing testimony about his ASD to explain his courtroom behavior amounts to judicial endorsement of improper evidence. If anything, presenting evidence of defendant's ASD will focus the jurors even more on the defendant's behavior that they likely would not have noticed in the first place. It may also diminish the weight assigned to the evidence the jury is instructed to consider in aiding in determination of guilt, despite instructions to the contrary. It essentially invites the jury to consider the character of the accused to determine guilt, which is not proper except as allowed by 404. In this sense, the evidence runs the risk of being unfairly prejudicial to defendant. In addition, it plays a risk into the jury's sympathies to the prejudice of the state. Moreover, expert testimony, particularly on a diagnosis as encompassing as ASD, will consume a significant amount of time in an already lengthy trial. Consequently, if defendant does not testify, evidence of his ASD to explain courtroom demeanor is inadmissible under 401 and 403. Then there's a footnote. Defendant's ASD can certainly be raised in voir dire, including questioning the jury panel about whether they can avoid judging the defendants improperly based on how he presents at counsel table, which may allay the defendant's concerns about how the jury may perceive him. And I told you, I thought that was totally proper to discuss in voir dire on previous shows that we talked about. I remember once I had a guy that had tattoos all over his head. We just discussed it in voir dire. Most people are like, yeah, don't care. If, however, defendant testifies, evidence to explain his demeanor may become relevant. At that point, the defendant's demeanor, which goes to his credibility, is relevant evidence a jury can consider, which the state concedes. However, prior to presenting testimony on the matter, the defendant must raise the matter with the court outside the presence of the jury to discuss the permissible scope. 2. The court reserves ruling on admissibility of OCD evidence. Defendant argues that the evidence of his physical manifestations of OCD may be relevant in rebuttal. Those manifestations, according to Dr. Orr, include compulsive hand washing, wearing gloves to avoid germs, and generally avoiding anything contaminated. The defendant further adds an argument only that his OCD causes sleep difficulties that has led to a habit of night driving and running to decompress. Dr. Orr noted in her report the defendant engages in self-soothing activities to decrease sensory inputs caused by his ASD, to include spending extensive time in the dark and driving. This was not linked to his OCD, however. He argues that if the state elicits testimony at trial related to the facts in order to support elements of the crime, evidence of these manifestations will be proper rebuttal. By way of example, he notes that just prior to his arrest, law enforcement saw him wearing gloves and handling baggies. Believing he was destroying evidence, law enforcement abbreviated its knock and announce procedures. If the state introduces this or similar evidence at trial, the defendant asserts that evidence of his OCD would be relevant rebuttal to offer another explanation of the behavior. The state responds that it does not intend to introduce any evidence during the guilt phase of the defendant's odd behaviors, social miscues, or other unusual behaviors. However, it requests that the court reserve ruling until the time of trial. The court finds this is an appropriate approach. Again, prior to introducing such evidence or otherwise mention it before the jury, the defendant shall raise the matter outside the presence of the jury. Evidence of OCD is not admissible to rebut ability to commit a crime. As with his OCD, defendant argues he intends to introduce evidence of deficits in his fine motor dexterity and visual motor functions caused by DCD to rebut the state's evidence that it was possible for him to have acted with the speed and coordination required to commit the crimes. The state responds that the defendant is improperly stretching the bounds of his expert's opinion to reach an inference that cannot reasonably be drawn, which was not disclosed and which otherwise has no support. It argued that the evidence is not relevant to guilt and or barred by Rules of Evidence 403. The state's challenge is well placed. Whether the defendant was physically capable of speed and dexterity to commit the crime on account of DCD is within the realm of expert opinion. As Dr. Lewine observed, DCD is characterized by impairments in the development of the motor coordination, including dexterity, limb speed, and gross and fine motor skills. It is associated with structural and functional disruptions of motor controls and coordination networks with minimal modulation of psychological factors. However, it is not a diagnosis from which defendant currently suffers. In her report, Dr. Orr noted DCD was a diagnosis for which defendant met the criteria in the past. Further, there is nothing in her disclosure or report suggesting defendant was physically unable to commit the crime due to impairments associated with DCD. Her entire discussion on defendant's DCD is as follows. Defendant's educational history, parent report, and evaluation results all provide evidence that the defendant experienced significant deficits in motor functions in the course of development, which in turn contributed to the problems meeting physical, typical motor and coordination milestones of childhood. Examples: problems catching balls, handwriting, riding a bicycle. While motor problems have not impacted his functioning significantly in many years, defendant continues to present with impairment in fine motor dexterity and vulnerabilities in visual motor functions, evidence in his cognitive profile and observations of his behavior. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was that the defendant moved his whole arm and repositioned his upper body slightly to manipulate the items effectively. In her cognitive profile, she stated that defendant's visual motor skills were relatively weak in the context of his overall profile, particularly when precision or dexterity were involved, copying visual motor sequencings, for example. Consistent with his history of fine motor deficits, when isolated, Bryan's fine motor dexterity and speed were impaired bilaterally, likely impacting his visual performances as well. The foregoing represents the extent of expert commentary on defendant's DCD. Nothing therein remotely approaches an opinion about defendant's ability to commit crimes. At most, Dr. Orr could testify about her observations about his weak fine motor dexterity and visual motor skills, but without any opinion tying this evidence to his ability to commit the crimes. Its relevance is lacking, and it invites unsupported speculation by the jury about the defendant's ability to commit the crime. Additionally, there is again the concern the expert testimony will consume an inordinate amount of time on an issue for which there is no foundation of trial that will already be lengthy. Weighing these concerns against the lack of probative value further warrants its exclusion under 403 as the state of the evidence stands currently. So therefore, based upon the foregoing, the state's motion in limine regarding the neuropsychological and psychiatric evidence is granted in part and reserved in part. So we went over that, like I said, real quickly last time, but I think it was important to note, there's been all this talk that Bryan Kohberger was unable to commit the crimes because he has these deficits. He cannot physically have done this in any way. Well, even the defense's own experts say, yeah, that's not a thing. And although they may be able to say, yes, I saw some slight uncoordination, I guess you could maybe argue that at closing, but it's certainly not going to be allowed to come in as an expert witness. So therefore, the defense did not fare well on that one. And it's a real tough argument to make. It'd be one thing if, for example, the case that was cited in the court's order where the guy had Asperger's and was just doing things completely inappropriate, where the court grew concerned about it. At that point, you may be able to explain something away. But here you have a guy that maybe he has some quirks. Let's face it, don't we all have quirks? Of course we all do. His is he likes to wear gloves. Okay, that doesn't necessarily mean that he was destroying evidence. It just simply means he was trying not to, he was trying to avoid some sort of contamination. And so the police obviously didn't know that when they were, looking to arrest him at his parents' home. But his parents or family members may be able to testify to that. Yeah, he wears drugs. He's just got this thing. He just likes to, avoid anything gross and that could be contaminated. So cross-examination is, he's got this issues. He's got this issues. Detective, yeah, it wasn't really this. It's the classic. Sometimes things aren't always what they appear to be, right? And you can leave it at that and then save that for argument. So there you go. As obviously as we approach the Bryan Kohberger matter, these orders, both from Friday as well as the one we went over today, they set the stage. They set the stage for the rules of evidence, what is coming in and what is not. And right now, it's pretty much as we expect it to come in. No real surprises from the judge on the rulings. And frankly, all rather very predictable. All right, next on the docket, we will bring you, if we haven't done so already by the time this video airs, the closing arguments of Lori Vallow. Obviously, she's on trial for conspiring, allegedly, with her brother, Alex Cox, to kill her fourth husband, Charles Vallow. She's represented herself. Closing argument is going to start today. She did not present any evidence when the defense had an opportunity to present a case in chief. Frankly, good call. I'm telling you, from the defense perspective, I've won more trials when the defense does not present any evidence. You poke holes in their case and just simply argue that the case was not proven beyond a reasonable doubt. Next on the docket, another teacher in trouble. And why do I bring you this story? Well, I was looking back. I apparently made a comment a couple weeks ago, said, you should probably be concerned about, who's teaching your kids. And somebody took it the wrong way and basically thought I was saying that all male teachers were trying to do inappropriate things with their kids. So that's not what I meant. I'm just saying it seems like a lot of teachers seem to be getting in trouble, whether male or female lately. And one of the reasons why, one could say is that they have a certain proclivity towards young people. Not all of them. I'm sure there's people that taught for years and never did anything inappropriate. But if you do have a problem and want to conduct things, you go to where the people are that you want to be around. Hence the reason for teachers getting in trouble a lot. Anyway, this Arizona teacher, a guy by the name of Eric Curtis Chapman, was nothing but smiles when he appeared in court. So like I said, the teacher was in court facing charges of sexual crimes related to children, and also apparently filming himself while having sex with students on campus. That's bold. So like I said, Eric Chapman, the guy's a 43-year-old teacher and a baseball coach at the Cortez High School in Phoenix, was arrested last Wednesday after a tip first led detectives to find nude photographs that he allegedly sent to minors. The teacher then allegedly admitted several sexual interactions with the students, including filming himself with some in several areas of the school campus. This guy really should have kept his mouth shut. Anyway, Mr. Chapman allegedly admitted to sexual interactions with 2 current students, both minors, as well as a former student who is now an adult. What's concerning to the state, the prosecutors, is when officers interviewed Mr. Chapman, he admitted to sexual acts happening as recently as last week. Anyway, Mr. Chapman also admitted to downloading hundreds of sexual exploitive videos and photos of minors. This guy's going to prison so long, he has no idea what's coming his way. Anyway, like I said, he faces multiple counts of sexual conduct with minor and sexual exploitation of a minor, and is being held on a $250,000 cash bond. It's scary in the day that we send our kids to these days, ladies and gentlemen, that you don't know if one of the teachers could be a child sexual predator. That's all I'm saying. Anyway, the teacher was fired as soon as the allegations came about, and he no longer has any duties at the school. Good call, school district, right? And, I'm not trying to do anything, but I just don't get it. My guess is there was some, these guys target people that have issues. This 43-year-old guy, I'm just taking a look at him here. I just don't see him necessarily, what's the word I'm looking for, being the dream of every 14, 15, 16, 17-year-old high school girl. Just don't see that. But hey, maybe I have been wrong or could be wrong. I guess it's possible. Next on the docket, the banker accused of helping former South Carolina attorney Alec Murdaugh hide his money. He's pled guilty to federal wire fraud charges. Remember Russell Laffitte? He entered a plea of guilty after convictions on the same charge were overturned by the appellate court last year. Laffitte was one of several people that were brought down by Murdaugh, as well as he stole millions from his law firm and his clients in wrongful death and serious personal injury cases. The same Mr. Murdaugh is serving a life sentence, multiple life sentences for the killing of his wife, Maggie, and son, Paul. Anyway, last Friday, Mr. Laffitte entered a plea of conspiracy to commit wire fraud and bank fraud. Separate wire and bank fraud charges are misapplications of bank funds. And under the terms of the agreement, if Laffitte comes up with $3.5 million in restitution before his sentencing, guess what? Prosecutors agreed to propose a 5-year sentence. That's a pretty good deal. What do I tell you, ladies and gentlemen? It's always about the money. And, Laffitte just happens to maybe have an extra $3.5 million hanging around for restitution. Get 5 years. He was already in custody. Man, he won't hardly do any time. It's always about the money, ladies and gentlemen. And particularly if it's a theft case, they want the money. They just want the money back. Something to think about. Next on the docket, let's talk about a case here in Colorado that just screams extreme indifference. Basically, the gist of the case is 3 high school kids that were over the age of 18 were throwing rocks off of the top of a bridge, and one of them killed an individual that was driving underneath the car. A beautiful young woman. I think she was 16, 17 years old. Anyway, it's a pretty gruesome story. 2 of the teens have pled guilty, and the 2 are testifying against the young individual that's also on trial, a kid by the name of Joseph Koenig. Anyway, the testimony was that he was quite excited after he threw a rock into a passing car's windshield and killed the drivers 2 years ago. His friend testified Friday during Koenig's jury trial in the Jefferson County District Court. That's maybe about 20 miles here from the CrimeTalk studios. Anyway, Koenig apparently let out a big whoop when he saw 20-year-old Alexa Bartella's car had actually veered off the road after it was hit with the rock on Indiana Street near the Rocky Flats National Wildlife Refuge on April 19th of 2023. So Nicholas Mitch Carroll Chick testified to that on Friday. He was quite excited, Carol Chick told jurors. He would just look at us with this big smile on his face. Now, Koenig's charged with first-degree murder in Barella's death, as well as attempted murder and related counts for his role in throwing rocks, according to the prosecutors. The police allege that he, Carol Chick, and a third teenager, Zachary Quack, carried out the attacks, basically. Now, the teens threw landscaping rocks at a number of cars, both parked and moving, before hurling rocks through Bartell's window in the last attack of the night. All three men were 18 at the time of the rock throwing spree. Each is now 20. Koenig's celebration after hitting Bartell's car was in line with how they reacted in past impacts, Carol Chick testified. Now, the men would cheer and compliment each other whether a rock struck a vehicle. If they missed, they were disappointed, he said. Even Koenig's defense attorneys have all but conceded he helped to cause Bartell's death and said that he should not be held responsible. But they argued that during opening statements that he was guilty, just not of first-degree murder, but of the lesser serious charge of manslaughter because none of the teenagers intended to actually hurt anyone that night. We only thought of them as cars, Carol Chick testified, but we never thought of who may actually be driving them. So Quack and Carol Chick have both pled guilty in Bartell's killing, and as part of their plea deals are required to testify against Koenig. Now, prosecutors say Koenig threw the fatal rock. Koenig's defense attorneys say Quack threw the fatal rock. Now, following his arrest 6 days after the killing, Carol Chick for months told investigators that Quack threw the rock that killed Bartell, including through 3 proffer interviews in which he offered information to prosecutors in order to seek a plea agreement. It wasn't until the 4th and final proffer interview did Carol Chick finally name Koenig as the person who threw the last rock. Carol Chick admitted on cross-examination, quote, "You knew what you needed to say in the last interview," Martin Stewart asked of Mr. Carol Chick. "I did," Carol Chick responded, "and that was that Joe threw the rock," Stewart said. "I knew that I had to tell them the truth," Carol Chick said. "Well, you started out saying that you are 100% sure that Joe threw the rock, and by the end of the interview, you are." "That is correct," Carol Chick testified. He testified Friday that he lied until the last interview to try to protect Koenig, who was at the time his best friend and almost close enough to be his brother. Quack was a newer friend who the pair had known for only about a month. He said he agreed to pin the crime on Quack after talking with Koenig after Bartell's death, and they went over everything that happened, and it was at that time that Joe and he met, and they wouldn't worry about it, and they were just going to say that Zach did it. But under cross-examination, Carol Chick testified he genuinely believed Quack threw the fatal rock, and he thought he remembered Quack handling that particular rock, which was bigger than the other rocks they collected. He testified that he told Quack not to use that rock because it was too big, but the Quack told him that he would throw it if Carol Chick wouldn't. The rock weighed approximately 9.3 pounds, the detectives testified to, and the defense attorney suggested that Carol Chick pointed a finger at Koenig only to secure a plea deal with the district attorney's office that will allow him to avoid a life sentence in prison. And he tailored his testimony to match the prosecution's theory of events after the prosecutors offered him no deal after the first 3 interviews in which he named Quack as the person who threw the fatal rock. Was the truth that Joseph Koenig threw the rock that killed Alexa Bartell? Chief Deputy District Attorney Catherine Decker asked on redirect. Yes, Chick testified. Quack said he didn't throw any rocks during the several hours that he hung out with the other teenagers that night, and he asked to go home. Carol Chick said all 3 teenagers threw the rocks and that Quack never asked to leave. Now, Carol Chick also said Koenig was driving at about 80 miles per hour when he threw the rock that killed Bartell, which Quack said the speed was 103 miles per hour. Both testified that Koenig sped up before the fatal throw. Anyway, the 2 men's testimony aligned on the major events of the night, including the fact that they carried out a series of escalating pranks of rock throwing before Bartell's death. Now, after her death, Carol Chick said he knew they'd effed up when he drove by the area again later that night and saw the emergency vehicles, he testified. Now, Mr. Carol Chick faces anywhere between 35 and 72 years in prison. Quack could be sentenced between 20 and 32 years in prison. Koenig faces a mandatory life sentence in prison if he is ultimately convicted. So obviously extreme indifference is different than after deliberation. But extreme indifference is like, throwing a rock over the overpass onto on-moving traffic. It's very likely that behavior is extreme indifference to human life. Of course, somebody could get hit. Another example, if somebody went out and shot a firearm down a crowded street, it's extreme indifferent, and it is not a good case. Now, I don't know what's going to happen in this particular case. You got 3 kids all trying to protect themselves. Telling an 18, 20-year-old kid you're going to go to prison for the next 20 to 72 years, that's a tough thing to do, let alone when you're 18, knowing you're going to go to prison for the rest of your life if you're convicted. But you can't engage in such stupid conduct where somebody could get hurt, or in this particular case, Miss Bartell gets killed. Next, this day in legal history, April 21st, 1789, John Adams is inaugurated as the first United States vice president, establishing legal precedents for executive succession and the constitutional roles. On this day in 1926, the Federal Kidnapping Act's early drafts are discussed, prompted by rising abductions, later criminalizing interstate kidnapping. And on this date in 1963, April 21st, 1963, the United States Supreme Court hears Brady v. Maryland, which later mandates prosecutors to disclose exculpatory evidence. Yes, we still are arguing over that. Since 1963, you have to turn everything over. Then on this date in 1967, the Katz versus United States case is argued, later expanding Fourth Amendment protection against warrantless wiretapping. And on April 21st, 1995, Timothy McVeigh is arrested in the Oklahoma City bombing, leading to the Anti-Terrorism Act of 1996. And then finally, our dumb criminal of the day. Well, doesn't this escalate quickly? Take a look at this unidentified man. Simply gets advised, hey man, you got a warrant by the police officer. And then he says, no, I'm not going. Basically, it's just not a good time for me to go today. And by the end of it, well, he says he's going to kill everybody, including the police officer. Not good. Anyway, unidentified man with a warrant, you are a dumb criminal of the day. Congratulations. You can add that to your accomplishments in life. All right, that's all we have for today. Thanks for watching. We'll see you next time. Remember, the Constitution matters.